There is currently no statutory framework to assist where adults either cannot communicate decisions or are unable to make decisions for themselves, but all that is about to change. Last Tuesday, the Capacity Bill 2022 received its final reading in Legislative Council and returns to Keys this week for final approval. So why has it taken so long to introduce this legislation, and what impact will it have? I'm joined on the programme by Health Minister Laurie Hooper MHK, Tanya August Hanson MLC and Rob Mercer MLC. Miss August Hanson moved the Capacity Bill in Legco. Why is this bill so important?
Essentially, it's for people that lack capacity to make decisions for themselves. So it places on a statutory footing fundamental principles that apply to decisions and actions that are taken under the Act. So essentially, when a person is said to lack capacity, then an act done or a decision made on their behalf needs to be made in that person's best interests. And if you've got the principles in the legislation, is a section in the legislation that speaks specifically to those principles, and then also the best interests, those are the most important parts of that particular piece of legislation. So it includes sort of considering so far as is reasonably ascertainable their beliefs and their values, and that informs the right course of action that's sort of needed to be taken. It also includes sort of provisions on lasting powers of attorney. At the moment we have enduring powers of attorney that speaks to mainly financial matters, whereas this includes the sort of health and social care provisions that somebody would wish to make in advance.
Okay. I suppose the obvious question, and maybe Minister, you'd be the best person to answer this one, is how is it that we've managed so far to do without this sort of legislation? Because it does seem as though it is governing an area of particular social need.
Yeah, I think for a long time this has been kind of common law principles or things that are embedded in ethical practices that doctors will do as a matter of course. I think what this bill is trying to do is place that on a much firmer footing, a statutory footing, so that everyone is absolutely black and white, absolutely clear as to what has to happen when considering whether or not you can make a decision on behalf of somebody else. Because don't forget, what we're talking about here is where someone doesn't have the capacity or the ability to make a decision themselves about their own care or about their own finances. And so that needs to have quite a robust framework around it to make sure that when people are making decisions on behalf of somebody else, that those people are protected from potential bad actors or people maybe not acting in the best interest of the individual that doesn't have capacity. And so whilst we've had a regime that has worked, for broad definitions of the word worked, it has worked on the island for a long time. This is really intended to take this into the next stage of making it much more robust. And the reason that I think it's necessary, the reason this has come about in terms of timing, is there's a lot of other legislation coming down the line that I think needs to have this on a statutory footing so that the other pieces of legislation can come forward.
So at the moment, Tanya, I mean, if someone is, and it usually is a case where someone's approaching the end of their lives, and their capacity is starting to wane, their capacity to make decisions on their behalf. What's actually changed through this, or what will change through this legislation when it's enacted, that will give the persons affected more reassurance?
The main thing, I think, particularly with the lasting powers of attorney, is the fact that they're able now to sort of start looking at their own healthcare, their social care provisions, and what they would like to see happen in the future should they not have capacity. Should they not be able to take decisions in their own best interests, in sort of deciding who best would support them in doing that. I think it's very, very empowering for people. I think that there's something that's been missing on our statute book, and I have had sort of cases which I won't go into the detail of, but cases of individuals that I've talked to in relation to capacity and how it's kind of rolling out at the moment, that would be directly affected by being able to make those provisions, and their lives would be far easier if they could do so.
And Rob, I mean, you've apparently taken a great interest in this because you moved a whole series of amendments in I think it was the 22nd of November sitting. What's your particular interest in this?
Firstly, I must say that most of those amendments were government amendments. and they're a response to some of the points that were raised in Key's questions outstanding, really, from Key's, particularly from Minister Thomas. Some of those are technical amendments, the correction of a mistake in language. So really, my interest in it is to make the bill, as good a starting point as it can be.
Okay, and well, let's have a look at some of the amendments. The Department must make regulations in respect of a register of delegates. So that was an amendment to Clause 28. Are these not the sorts of things that you'd have expected the Department to have picked up on before it actually got to the Legislative Council? Minister.
So this is quite a common one, actually, that you see. So quite often when you go in with a piece of legislation, you'll have the Department may do something, and the expectation is the Department will, but you don't want to place an absolute obligation on the Department to do a certain thing because of the costs involved sometimes, or just because it may be that it happens further down the line, and you may want to bring the provisions in and not be forced through a timescale that doesn't quite work for you. Inevitably, though, when it hits the floor, I think there's a bit of nervousness amongst members about saying, right, if it says may, are you really going to do it? And so sometimes you end up with people saying, actually, this needs to say, you must, you shall do these things, rather than leaving it open-ended. So I think there are, sometimes it is just about nuancing the language, it's about getting that confirmation, I think, that gives Tynwald the confidence that when the Department says we are going to do something, okay, well, if you're going to do it anyway, it may as well say must, there's no harm. And that amendment happens quite a lot. You'll have seen that yourself in your own time in the Keys. It's not an uncommon thing to change that kind of language to make it a bit more firm, I think.
So why do you have to have this register? Why would it not be just possible to leave it as a may? Because presumably, from what I can see, that there's a formal process that has to be undergone for someone to be appointed to act on behalf of someone who loses capacity. So that formal process is going to be recorded somewhere. So why do you need to have the register?
I suppose that the logic is you need to have all the information in one place. So in terms of lasting powers of attorney, actually having a central register where anybody who needs to know can know whether you do indeed have the right to make decisions on behalf of somebody else, and have that stored in a central way where actually even you yourself, someone may have made a lasting power about you that you may not have been aware of, and that shouldn't happen now under the new bill, because actually it needs to be registered, it needs to go through that formal process. The must-may thing is about the regulation-making power that sits underneath it. So the Department may have said, actually, we may need regulations to talk about how the register is going to work in practice, how things will actually happen on the ground, and again, that's where Tynwald will, obviously in this instance, there was pushback where Tynwald members were saying, actually, we need you to make those regulations. And in some ways, it's easier for the Department to accept that change rather than either fight it, which may have be unnecessary, seeing as the Department was going to do it anyway. Or sometimes if the Department pushes back and says, well, I'm not making regulations, Tynwald members may decide to try and insert more changes to the primary bill itself to get what it is they want. And so sometimes it's just an element of it's easier to compromise on the ones where you can happily compromise on something like that, which is a terminology change rather than a big fundamental change in policy.
Tanya?
Sometimes it's just good to find consensus, and in finding consensus you find a really sensible solution actually that suits everybody, and is probably the solution you should have come to in the first instance, but it's taken you a little while to get there. This kind of makes perfect sense, and this is what the branches are here to do, is to sort of like make sure that the engineering is correct in the legislation, and for Keys, to bring something up that they find concerning in terms of policy. I think it's very, very important that Legislative Council do then try and pick those things up and have a look at them, and potentially suggest amendments alongside the Department.
One of the other amendments that you moved, Rob, was in relation to allowing the Department to charge in respect of the functions under Section 29. Well, when I had a look through the Section 29, or Clause 29 as I would prefer to call it, this was things like supervising delegates appointed by the court, ensuring delegates act in compliance with the bill, dealing with representations which include complaints about how a delegate or donee is acting. So potentially the Department can charge for someone who wishes to make a complaint about someone acting on behalf of someone who's lost the capacity to make their own decisions. And that charge may result in the person being unwilling to actually make the complaint because they can't afford to make the complaint. Is that something that's been considered, and how are these charges likely to be made?
I must say that obviously I don't speak for the department, so I'm going to defer part of that answer to the minister on my left here. But the amendment to make charges is restricted to those supervisory functions, and so it seemed a sensible restriction to me in terms of its operation. I think I will defer the rest of that question.
And well, Minister, then, I mean, I have, in a different sector governed by your department, had experience of charges which basically have put some operators out of business because they're just too onerous and too difficult. So how can we, the public, be assured that this bill, which ostensibly is there to help, isn't going to be just seen as the department turning around and saying, well, we can't afford to do this, so we're going to whack a whole load of charges on for people to access the
core principle of any regulatory system is that really the costs should be borne by those who are being regulated. So that's the way our financial services sector is supposed to work. It's the way the GSC is supposed to work. It's the way all of our regulators
and I could understand that for businesses, but I mean, these are people who are probably going through some extraordinarily difficult times. So and you're going to charge them.
So this bill, this section talks about the supervisory functions, about the actions of delegates. So the delegates themselves, not the individuals who have lost capacity. I think it would be quite unusual for the department to charge for things like making a complaint. That would be a very strange decision to make. But I can see when the department is required to do things like receive security. So if the court instructs that the department must receive security, actually that's an imposition on the department by the court. I can understand why, if you have to go through formal court processes, if you have to register things, then actually if there is a cost that the department is then bearing, I think it does make sense to say there would maybe have to be a charge for things like that, because don't forget the functions of the Department of Health and Social Care are not limited to simply regulating this bill. The actions of this bill is also about running the whole health service, and so if you don't find a reasonable balance, you're going to end up saying, well, actually, because I have to perform these functions, which, coming back to the may and must argument, the department must do these things. Where's the money going to come from to perform these functions, as well as trying to balance that with the need to deliver on healthcare? I can't imagine the costs of this are going to be such an extent that is going to actually have that kind of effect. But I think when you're making primary law, you have to put in the backstop that says, well, on the off chance we do need to do something, we've at least got the power to do it. So my understanding is I don't think there is any intention by the department to start introducing a raft of complex and burdensome charges on the public for things like this. But ultimately, I think it's better to have the power and not need it than turns out that you do need it and then you don't have it on the books.
It seems, though, a little like the counter argument to the one that you put for the moving shall to may for the register, that this is the opposite way round. You're basically saying that we may be able to do this, but quite frankly, why would you put it in? I mean, you've already described a number of the circumstances that are allowed for in this may provision as being highly unlikely that the department would ever wish to charge. So why have you allowed yourself the provision? I'm not wholly convinced. And it's a shame, because most of the bill is there for really good purpose.
So I think I've tried to outline that. I think that you'd rather have the power that if in case you need it. So monitoring the compliance of some of this, I think, will be quite complex, especially particular cases. Hanging off that clause as well, there's a power for the department to institute complex inquiries. And so if it turns out that the department has, say somebody makes a complaint, it causes a concern. Actually, if the department then has to undertake a significant piece of work to investigate something, actually, that's when you do start getting into that world of quite expensive actions ultimately. And again, I think from my perspective, you wouldn't want any kind of regime to put people off wanting to be able to make these kind of representations, to be able to make complaints, to register a lasting power, whatever it is. You'd want to make sure it's as accessible as it can be. But ultimately, I think it comes back to you'd much rather have the power and never need it, rather than turning out a year later, 2 years later, actually, we really desperately need this ability and it isn't there. And we have come across that in other acts, actually, where it turns out the department has needed the power to do certain things and the power just simply doesn't doesn't exist. And that, I think, is quite a dangerous position to end up in. This perhaps much lower priority than some of those other instances I'm referring to, but I'd be quite nervous, I think, if we were creating something which hopefully this bill will last a very long time in its current form, and so without having to come back and make changes in the future because of something that may happen in 4 or 5 years that we can't predict.
So trust me, I'm the minister. Seems to be the
ultimately, though, Phil, all of this stuff has to come back via Tynwald. So when you're making regulations, it will require Tynwald approval. And so this isn't the case where I think the department can sneakily apply a charge to individual sets of circumstances. Regulations made under these clauses will need Tynwald approval, and ultimately that's your common sense check and balance, if you will. That if you are doing something that is out of kilter with the public mood, something that is unreasonable, I would expect Tynwald to say, hold on a second, to whoever the minister is at the time moving those regulations and say, nope, you're not doing this, go back and try again. And ultimately that's your final safeguard on anything built into a may make regulations but must make regulations provision is Tynwald is the ultimate check there.
Okay. And Tanya, then, in your speech in relation to the first stage of consideration in LegCo, you mentioned that a person's capacity must be assessed on a decision-by-decision basis rather than making of blanket assumptions that a person cannot make the decisions on their own behalf. I mean, this sounds great if you happen to be a person of advancing years and concerned about potential powers that could be gifted to others to act on your behalf. But it does potentially cause a problem here in relation to who makes the assessment about whether a person has the capacity to make these decisions on their own behalf, and if, as certainly was the case in a personal example I had, it's the doctor, and we know that doctors are really struggling to manage to fit time in with all their patients. If we have to keep going back frequently to ask for new assessments for every decision that's taken, that could be a little onerous, or have I misunderstood that?
I think every single situation that one person might find themselves in may be very, very different to the last. I think that you've got, when we talk about decision by decision basis, at the moment, those decisions that are in the best interest of an individual are already taken on a decision by decision basis, where you will have a number of people, stakeholders, including medical and clinical professionals, around a table taking a decision on best interests regarding enduring power of attorney, say, for example. I think that, when we're talking about, say, for example, I'm sorry, I'm using the word example. If you have advancements in technology or advancements in medication regarding a certain treatment, an individual, it has specified that they want a certain type of treatment. But say, for example, you have a look at that situation, you have a number of people around a table looking at the best interests for that individual, and they have decided, well, that's fine. This decision was made a while ago. That person is now lost the capacity to be able to make the decision for themselves. There still needs to be some degree of consideration to whatever treatment is now available that perhaps wouldn't have been a treatment available at the time that they had taken the decision in the LPA, or lasting power of attorney. So it may prompt another conversation, if you get what I mean, and it would be perhaps a different conversation than perhaps in the same situation would have happened a year before or the year before that. So I think that, like, when we're talking about decision by decision basis, I think that every situation is quite complex, and you can't really, and the capacity of that individual may sort of ebb and flow change. They may regain their capacity and then lose it again. They may regain their capacity. So you don't know what you're going to be faced with until you're faced with it, and therefore the sort of round table on a best interest test, to sort of like go back to the fundamental principles and the best interest of that individual. I think it's very, very important that we do it exactly like that.
And again, I think later on you talk about defining what a person's best interests
as what being, we've done in the bill.
Well, I think you say the bill doesn't define best interests, as it would be too prescriptive.
Yeah.
But then I suppose the alternative side, or the opposite side of that coin, is by not defining what a person's best interests are, maybe you're being a bit too vague. So, I think don't know.
We need to leave it reasonably wide. I think that we do make some assumptions as to in the bill as to what best interest decisions are. I don't think that we need to go too far into the specifics, because again, I think that every single situation, that every individual is different, every situation is different. So if we start digging down and making it more prescriptive, then essentially we're opening ourselves up to error.
And it's the perennial difficulty that drafters and policymakers have when it comes to making legislation, whether it's too prescriptive or whether it's too vague, and getting the balance is never an easy thing to do. One thing, though, that you're quite keen to have prescribed is references to where legislation may have been I was going to say pinched from. What's your thinking behind that?
So essentially the motion in Legislative Council was regarding where a clause or where part of a clause may have been derived from other legislation, regardless of where in the world that it might have been derived from. And we talked about whether or not it should include a note of relevant derivation along with a sort of date reference as well, so that we're able to timestamp that and then go back to whatever piece of legislation it's derived from and sort of figure out, okay, well, on that time and day over there, they have since made these changes, so that if we're updating a piece of legislation, we know what's happened in the place that legislation is derived from, and we can take those things into consideration. Essentially, a derivation is like a signpost for the reader as to the origins of a provision. So the research, I suppose, I think it's very, very important for people to be able to look and find and interpret and understand legislation, and particularly when it's social legislation as well, for them to be able to pick up a piece of legislation and be able to know exactly A, that it's accessible, but B, that that they're able to sort of navigate it well.
Because again,
so that's what it's about. Yeah.
I'm not sure how well the most people. I mean, you wouldn't expect the general public to have an in-depth knowledge of how legislation is drafted, because that's what you're paid for, is to do that for us. But in relation to this, of course, much or quite a lot of the legislation, whilst it is specific to the Isle of Man, it borrows clauses or sections from other pieces of legislation.
Sometimes, not always. I think that there is an awful lot of deriving in our legislation, whether it be in part or whether it be whole clauses, sections. Or, if we've kind of like had a look at a piece of legislation and elsewhere, so in Scotland, Victoria, from, wherever we've had picked up a piece of statute, we thought to ourselves, right, okay, well, we want to do something like this policy-wise, or it needs to be worded like that, that we should really be sort of referencing where we got those things from. I think that's quite important, but I think what's more important about that is being able to sort of signpost to whoever then picks it up, be it a policy officer, be it a drafter, be it a parliamentarian, or actually a member of the public, because I do think the legislation does need to be readable, particularly when it's social legislation. If somebody wants to pick it up and read it and they have an interest in it, then they should be able to do so. I think that they should have the opportunity to be able to understand where it's been adapted from.
That was Health Minister Laurie Hooper and MLCs Tanya August-Hansen and Rob Mercer. I had the very difficult task last year of having to make decisions for my dying mother. This new legal framework will certainly assist in clarifying what can and can't be done, and should give comfort to people of advancing years that their wishes will be delivered as far as possible. For now, though, I'm Phil Gorn. Goramayo, thanks for listening.